Hello, everyone, and welcome to another episode of our CME live streams. And tonight we'll be having a medical legal talk, and it will be by Datin Anit Kaur Randawa, who will be talking on issues on medical devices. And I'm sure this will be quite interesting to many of you. It's not the usual medical legal talk, but instead it will be dealing with something which many of us handle day to day, but may not be aware of the medical legal consequences of what medical devices are, what are the legal aspects, and so on and so forth. Okay, it's just past 8, and we are waiting for few more people to come online. So just a minute or so, a word from Dr. Shield, who has been kind enough to organize this series of medical legal talks for us all at Docs. Okay.
We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
All right, thank you, Dr. Shield. And first things first is I just want to go through some housekeeping slides. Now, there will be a CBD point which can be claimed for watching this live CME session. And for doctors, it can be claimed by scanning the QR code, which will be displayed at the end of the talk after the Q&A session. If you're watching on a laptop or iPad, you can use your phone and launch the MMA app and scan the QR code the usual way. For those of you who are not aware, if you got the latest MMA app, you can now watch on your phone, and the complaint that you can't scan while watching on the phone because your MMA map is on the same device, what you can do is take a screenshot of the QR code, save it on your phone. Then when you launch the MMA app, if you look at the bottom right, there's an option to look at the gallery or picture album. When you open it, you can scan from your picture album. Okay, so that solves a very uh, um, frequently mentioned pain point amongst doctors who are watching on their mobile devices. The QR code will expire after an hour or so. So if you're watching this, say, the day after or the following day, you can still claim points if you log into the MCQ module. With the link is below our webpage, okay? The docs.my/medical legal CME. So below that, there will be a link. The link is live at the moment, but the MCQ module will only be available after the talk. Okay, so you can answer simple MCQs and still claim the CBD point. For the dentists who are watching, you would have received a link to register for CBD points. If you haven't, it's also at the bottom below the live stream video. So click there to register and claim your CBD point. All right. So that's the CBD point section. For Q&A, if you're watching this directly on YouTube, you can make comments on YouTube. But we prefer if you use Slido, and or the Slido is already embedded in our web page, and you can view it at the bottom. But if you have a Slido app installed on your phone or you're watching on a laptop, you can scan the QR code and it'll take you to the Slido page and automatically into the Q&A section for this talk. In the Slido app, you can also enter 2180298 and it will take you to our talk for tonight. Okay. Just a friendly reminder and a request. You will help us so much. If you haven't already, please subscribe to our DOPS channel because we still get a lot of queries. How do we get notified that there will be upcoming talks and so on? If you subscribe to our YouTube channel, there's a subscribe button somewhere below. So you just need to click on it and hit the notification bell. So whenever we have something upcoming, you will also be notified that way. Though we do send out email blasts every month to keep you all updated on when our next session is. Next month again, we'll have SGMC Grand Rounds and another medical legal talk. So almost every month you get 2 points if you follow us, and within 10 months or so, you have your 20 points requirement for the year. Okay, now we will go on to the talk. Now, this is a pre-recorded talk, and so I will stream it, and then Datin Anit will come in at the end of it and to take your questions. Okay. So without further ado, I present to you Datin Anit Kaur's talk on issues on medical devices.
Good evening. Thank you for joining us today. Today, I am going to speak on an issue that is very important when it comes to all medical practitioners, whether you are a doctor or a dental practitioner, but not so often discussed. This presentation is going to be on issues on medical devices. I'll start with telling you what are medical devices. Well, I think most doctors would know it better than I, but these are just a few examples of visuals that you would see. You would currently even using a smartwatch is a medical device because it can track your pulse, your heart rate, your steps. That doctors use that to record. You have got devices for the eye, as you can see in the first part of that slide of mine. Then you can see that picture of a stethoscope, which is a fundamental equipment used by all doctors. You've got all sorts of things on that picture on the right of the slide, which are things like the inhaler, the syringe, the scissors, the type of instruments you would use in a surgery. These are pulse oximeters. These are all medical devices. Even the sling that you use to mobilize or immobilize a patient who has had a fracture, a pacemaker, even any implant that is implanted. So these are just a few examples. So what are the types of medical devices? We see so many in the market today. They are personal medical devices, wearable ones, portable ones, wireless, digital, and electronics. I hear robotics is a big thing now, handheld medical devices, medical monitoring devices, and hospital medical devices. So it's everywhere. What are the importance of these medical devices? Medicine has grown and has become so advanced that today medical devices are used in diagnosis and treatment of patients, confirming symptoms and history. Because if a patient says, I have pain in my abdomen, a doctor would sometimes say, can we do an ultrasound? Can we do some sort of imaging to check what is happening? If there is a pain after a fall, an orthopedic surgeon would say, can I have an X-ray or a CT scan or MRI on the arm to see whether there is actually a fracture? So it confirms symptoms and history that patients give to the patient. It also allows a healthcare practitioner to exclude or include treatment options. Why? Because the pain may radiate from somewhere else, the symptoms may be coming from somewhere else, and your device will help you determine where it's coming from. To chart the course of treatment, it's a lot of times a confirmatory tool to be able to chart the course of treatment that you would give the patient. To track progression of the disease and improvement, these are all the images that you would use, the recordings, whatever devices are used, whatever CTGs, all these things would track the progression, the disease. If things have improved, it would tell you. And when it comes to implants, it's to replace human body parts. When you do a total hip replacement, when you do a total knee replacement, when you put in an implant for a while, when you insert a pacemaker for a patient to be able to proceed better, when you put in a chemo pot, it's to put something to facilitate treatment. So things like that happen. To monitor vital signs, absolutely important, and to assist in healing and rehabilitation. So you do use it on an everyday basis without realizing it. But what is the law that governs it? So in Malaysia, there's a statute on medical devices, and it's the Medical Device Act of 2012. This is an act that regulates the use of medical devices in healthcare for the diagnosis, prevention, monitoring, or treatment of illness or handicap, but it excludes drugs. So what we're talking about is equipment, devices, but not of drugs and medicine. So this is the act that governs it. What is the definition of medical devices? So Section 2 of the Medical Device Act 2012 defines medical devices. It is any instrument, apparatus, implement, machine, appliance, implant, in vitro reagent and calibrator, software, material, or other similar or other related article intended by the manufacturer to be used alone or in combination for human beings. And it's for the purpose of diagnosis, prevention, monitoring, treatment, alleviation of a disease, compensation for an injury, investigation, replacement, or modification of a support of an anatomy or a psychological process, support or life sustaining life, when you use the ventilator to give breathing support, control of conception when it's the IUCD, disinfection of medical device, or providing information for diagnostic purposes, medical purposes, in vitro examination, anything, whether it's pharmacological, immunological, metabolic means, but if it's assisted in its intended function by such means. And this instrument is to be used in the human body, but it also can be anything that the minister may taking into consideration public safety, health, or public risk, declare to be a medical device. So this is the full definition that is provided in the Medical Devices Act 2012. Now, how do you register a medical device? I know some doctors are very innovative themselves. They create something that facilitates some things that they do or treatment that they give. If a doctor or any manufacturer or any company would like to register a medical device, there is the regulations under Regulation 8 of the Medical Device Regulation 2012, which comes under the Act. And there is this how to apply for medical device registration under the Medical Device Act. It's this fact sheet, which is extremely useful. It sets down everything you need to know. This is how one should proceed if you would like to register a medical device. So registration of medical device, who is responsible for the registration? So the person responsible is the manufacturer of the device. So whether it's a company, whether it's an individual, you are responsible if you have manufactured that device, which is defined under Section 2, which we just dealt with. And in the case of a medical device manufactured in a foreign country, you have to have an authorized representative of the foreign manufacturer as defined in Section 2 of the Act in Malaysia. That's what the registration requires. So these are the medical device categories. They're all in those regulations. They can be for anesthetic purpose, for wound care, for medical devices to implement breathing, general active, non-active dental devices. All these categories are all listed in those regulations. Now, what are the obligations and who is obliged? Now, you can register it, but the obligation remains with the manufacturer. It doesn't then pass down to the user. So it's a consumer-like situation. When as a healthcare practitioner, you are a lot of times given a training on how to use a particular medical device. So the user training has to be given by the manufacturer. The manufacturer also has to conform to the prescribed essential principles of safety and performance. They need to ensure it's safe. They will tell you what it can and cannot do. And they have to ensure that it's manufactured with good manufacturing practice, with any written directive by the authority. It also requires the manufacturer to have it labeled, packaged, and marked in accordance to the prescribed manner. So those are all the manufacturer's obligations. Why? Because then, as the consumer, the healthcare practitioner or the dental practitioner can be guided by those manufacturing leaflets that have been put down by the manufacturer. So the medical device duty and regulations also outlines each establishment's post-market responsibilities. So you register it, you bring it out to the market, healthcare professionals start using it. What are then your obligations? These are all in the 2019 medical device regulations under duties and obligations. So those are the manufacturer's obligations, and they continue. They continue for as long as the product is in the market. What are the doctor's obligations? Well, the Malaysian Dental Council Code of Professional Conduct, where dentists use a lot of implants, right, especially orthodontic, they have set this out and said you have to provide a high standard of care which is evidence-based. You have to obtain informed and valid consent for the treatment. So you need to tell the patient that a device is going to be used, what the device is, the cost, and maintain clear and accurate health records when the device is used. Similar thing would apply to not just to dental practitioners, but to medical practitioners, that if you're going to implant something or use a device or put in a plate to secure a fracture, which would then be removed later, all this has to be informed. I know with spinal surgery, a lot of times you have to put in implants, and the doctors would normally counsel, give you an estimate. Similarly, when it comes to ophthalmology, these are all obligations of the doctor, which is the user of all these devices, to inform the patient who is the end user. So what do you do when you use it? You not just tell the patient, you then have to keep proper records. You keep records of what you advised, whether you gave them the leaflet, whether they had any questions. If patients come back with questions, sometimes you don't have the answers. You have to go and get it from the manufacturer. And that is okay. But if you've used it many times, the patient will say to you, oh, how good is it? Oh, I've used it on that many patients. I've got a register. This is my track record. I would recommend this. Why you would recommend this? So these are all counseling that happens before a device is suggested to a patient. And you need to record it. And you need to record that the patient consented to it, especially if you are advising on the use of the device. Sometimes we have patients today that are so educated that they will come and say, I had a family member who had this device done for this procedure. I would like the same. Then your duty would be to say, have you read about it? Are you very sure? Do you want any further information? And if they don't, then you record it. If they do, it is good to document whatever the discussion is. It's a dialogue. It's a process of the consent taking. And this is something that needs to be done when you recommend a medical device. Okay, so maintaining distribution records of a medical device. So normally the device is sent to your clinic or your hospital or basically your healthcare establishment. What is the duty then when that device is sent there? So the establishment shall ensure that the distribution record of each medical device manufactured, imported, exported, or placed in the market contains the following information. 1, the postal address of where it's sent to, the address and place of storage of the medical device, identification, details of delivery, receipt of the medical device so that it's traceable, and any information or documentation of the disposal of medical device if later on it's disposed, and any other information that is so required by the authority. These are all essential information that needs to be recorded. These are prescribed by the law, by the guidance document, so it has to be complied with. What else do you do? Additional information for implantable medical devices. Okay, so that was general medical devices. These are those that you implant. You need to keep details of the healthcare facilities. These are manufacturers, right? They need to keep details of the healthcare facilities where the implantable medical device is implanted or used. So the name of the hospital, details of the patient on whom it was implanted or used, date of the implantation, details of any removal if applicable. So it's all very regulated. It's for patient safety and it's for the end user patient safety that all this is done and needs to be complied with. The establishment also shall maintain distribution of record for 2 years after the medical device is supplied or exported, unless it is projected useful life, that it should be maintained for its projected useful life. So if it's one that's used for a while, like a syringe, the distribution record only needs to be kept for 2 years. But if it's projected for useful life, like a pacemaker, 5 years, 10 years, then you have to keep it for that time, right? And this is determined by the manufacturer. Notice the role of the manufacturer as a coexisting partner to the healthcare industry when doing medical devices. Now, the next one, the information in the patient's medical record is always recorded, but why? Whose responsibility is this? We've gone through this a few times. I'm sure, but it's the patient's right. But medical records are the property of the hospital. Why? So that it can be easily retrieved. Because nowadays, when you implant, let's say, a lens, there is a card that's given to you. When an implant is done, even of a pacemaker, a card is given to you. When an implant is done of an IUCD, there is a sticker or something, and you are informed that this was the manufacturer, this is the date. Everything is, there's a coexisting record, one that's passed to the patient and one that's kept by the hospital or the healthcare facility where it's done. So these are records that are kept by the hospital. It may be the right of the patient, but the safety of those records is the duty of the hospital, and they will keep that as their property. Now, health personnel has to make records for any events that happen as soon or as possible afterwards. So as soon as you implant it, as soon as they come back with problems, everything has to be recorded, and this has to be kept with the patient's medical records. What other duties do you have in maintaining the distribution records of the medical devices? You have to keep accurate, up-to-date, factual, objective, legible records, relevant details of medical and dental health history, clinical findings, including dental charting, investigations, treatment plans, treatment carried out, medication prescribed, any information of any rejection of those devices or what has happened. And this has to be given to the patient's family members or any other relevant management in the form that can be shared by other healthcare practitioners. And this is what we called the cards and things that they've all now come across. Now, next, it must be stored in a safe and secure room at all times when not in use. That's the duty of any person keeping any medical device. And the medical records of the patients also have to be kept for a minimum of 7 years from the patient's last visit or the date the patient attains the age of majority. all well and good. You know that you've got a medical device, how to register it, if it's distributed, when you use it, how do you maintain the records? Now we come to a different part of medical devices. What if there is a product recall? Because normally there's testing done before a product is registered. But sometimes after the use of the product, complications arise, and then the manufacturer has a duty to recall those products. And if they're going to recall the products, what do they do? So this is the process flow of how they would recall the medical device. Firstly, problem identification, risk assessment, and decision to recall, whether it's a voluntary one or whether it's instructed by, let's say, the Ministry of Health, because this medical device regulation is parked under the Ministry of Health. The minute you have identified whether you're voluntarily going to recall it or it's by instruction of the ministry, you then prepare a recall strategy. How you do that is internal within the manufacturer, but it has to be informed. And then the authority needs to inform the affected person of that recall. And this is why those records were extremely important. A lot of times, the recall is advertised in the newspaper previously, now on social media. But if there are records of who the end user has been, there should be a notification to that end user. And this has to be done in collaboration with the healthcare provider. So the first persons the manufacturer has to notify is the healthcare establishment and the healthcare provider, followed by the end user. Then it's the implementation phase of the recall. Then you execute the recall. You collect all the affected medical devices in stock, those that have not been used, and quarantine the recalled medical devices, and further action to eliminate recalled medical devices from the market, submission of final recall report to the authority, and then you will have an assessment by the authority. These are the implementation processes. Now, should there be a recall of a defective implantable medical device? What do you do? Because it's very easy to recall syringes, very easy to recall other things that have been used, but what about these devices that have already been implanted? Let's say something that's been implanted into the mouth, something that's been implanted into the knee. What do you do when it comes to that? Firstly, there's a duty to inform and execution of the recall of the medical device. Now, it is supposed to be like this. The establishment shall, before initiating the recall process, notify the authority affected and isolate the defective medical devices, cease the use of defective medical devices immediately, and cease the sale and distribution of the defective medical devices. Now, there are three classes of recalling. One is high risk, which has to be done within 48 hours. What is defined as high risk is reasonable possibility that the device will cause serious health consequences or even death. Class 2 is moderate risk, the probability that the device will cause a temporary or reversible health consequence, and there's a remote probability that the device will cause serious consequence, and that has to be done in 3 working days. And then finally, recall class 3, a low risk. So the probability that the device will cause temporary or reversible health consequences, or there is a remote probability that the device will cause serious consequences. And that recall class 3 has to be done in 5 working days. Now, the duty to inform and execution of the recall device with the establishment is a plan which has to be done at all levels of distribution, the consumer level, the retail level, and the distributor level. And in the case of an implantable medical device, it has to be tracked down to the patient level. When we started off with the slides, we showed that they were wearable devices. They were devices that were used as syringes, as stethoscopes. Now, those kind of things are quite easily tracked down with the first 3, the consumer, user level, retail level, or distributor level. But implants are especially tricky because it has to be tracked down to the patient level. And if it's not possible, it should at least be done to the healthcare facility. This is written in section 5 of the medical device guidance document, distribution records. Now, how are these recalls then done? They shall include a recall plan and strategy, notification to the authority, and the information on the recall device, location of the recall device being quarantined, or the action taken. Now, this recall records shall be retained and maintained for at least 5 years on top of the projected useful life. So early on, we said keep those records for as long as this device is in use. Now, but if it's recalled, there's an additional obligation to maintain it for a period of 5 years on top of the projected useful life of the medical device as determined by the manufacturer. But if the projected useful life of the medical device is 1 year, for example, right? It's plus 5, so 6 years. If the projected use of the medical device is 5 years, it's 5 plus 5, and it will be 10 years. So that's how you know how long you need to keep those records for. We've given you a discussion on what the rules are, what the regulations are, what happens when it comes to recall, and now we're coming to a case study. So this is a first case study. And this was a case where a patient saw an ophthalmologist for a cataract procedure. So this doctor uses a machine to examine and determine the power and the type of lens to be implanted in the patient's eye at the time of the surgery. So the machine used gives the reading, and based on the reading, a lens is ordered and commissioned, and that will be the lens that is implanted into the patient's eye, and then a card later given to the patient. So in this case, the reading was taken twice on the same machine, once during the consultation and once again upon the patient's admission for the procedure. The cataract operation proceeds, and the lens implanted is based on the reading of the machine. The patient then returns after discharge after the procedure and complains of a blurring vision. So the doctor tells the patient to give it a bit of time because sometimes there is some blurring because a foreign body has been implanted into the eye, but patient is dissatisfied. Patient then goes to another medical center, and a different doctor, another ophthalmologist, discovers the error in the reading. Then alerts the doctor, and the doctor is quite perplexed because they're very used to dealing with precision by machines when it comes to reading. And the doctor then discovers that this machine has not been calibrated for 2 years and not been serviced. So this raises a real question on how, when there is a monitoring medical device that is in any hospital, it has to be calibrated, serviced, and service records kept, because that would either be your defense if anything is brought to court, or your shield, or it would move against you if it had not been serviced regularly. So the patient then does corrective surgery at the different medical center, saying, I don't trust this first ophthalmologist anymore, then files a complaint to the MMC and also files a claim in court. So in this case, when it came to the MMC found that there was no breach of any ethical conduct by the doctor. The doctor had relied completely on the machine. The machine did not belong to him. The machine belonged to someone else who had not serviced it, but he was not aware of the records of service. So the complaint to the MMC was dismissed. But the claim to court didn't just include the doctor itself, but also included the healthcare provider establishment who owned the machine. So that was an issue that had to be sorted out, and finally this was resolved without a trial. So the takeaway lessons from this is that when you have records or patients that come back to you and say, this is unlikely, don't ever, as a doctor, don't ever say, the machine has to be perfect. So machines also need service, need calibration. It's good to check. It's good to sometimes check using a different machine. Why? Because it's patient safety. So if you use 3 machines and it all shows the same thing and all have got perfect calibration records, then you can say and put it in your records that with this complaint, I did use a different machine to check, and this was still found to be the same. So these are all issues that can arise and should be taken into consideration by any healthcare professional when dealing with a medical device or a complaint after one has been used. I will now move to case study 2. Now, this is a little bit more complicated because it involved a recall. So this was a patient who had a history of lupus, SLE, and he came in first and he was advised to have a left total hip replacement by one orthopedic surgeon in a government center. So that orthopedic surgeon had counseled him on the type of implant to be used and also conducted the surgery in 2007. So the type of implant that was recommended was a Deepway metal-on-metal implant produced by Johnson & Johnson. So this was advised and implanted, and this is done at the government hospital. A year later, he comes to a private hospital and says, I now want my right total hip surgery done. He'd got his left done earlier. He wanted his right total hip surgery done. And he said very specifically to the doctor in the private center, I would like to use the same implant that was earlier used because it has settled well with me. I like it. I know what it entails, and I would like to use that. So there was no counseling on the type of device to be used because he came in very specifically, I would like to use this. And the doctor took a history that, has it been okay with you? Yes, it's fine. So a date was scheduled and the left, and the right total hip surgery, replacement surgery was done. Now, in this case, what was also very, very peculiar was this patient had purchased the implant directly from the manufacturer. So the manufacturer had delivered it to the hospital. It was a direct purchase. The hospital didn't get involved. It's not part of the hospital bill. It had been purchased. It had been sent to the hospital for the surgeon to use on the day of the total hip replacement surgery. The patient was surgically discharged well and moved down south for a follow-up appointments because he did not want to have it done at that same hospital. He wanted it somewhere near his home. Then this doctor who was working in that private establishment left the establishment, went somewhere else, and that was in early 2010. A global recall of that implant was conducted. Now, the patient didn't know of that recall. The patient sought treatment in the same private hospital some 6 years after the recall for complications due to implant metallosis. And he claims he only learned of the implants being recalled then, when he came 6 years later. So under the recall policy of J&J at that point, he was eligible for a reimbursement program as long as the revision surgeries took place within 10 years of the initial surgery. So remember, we had looked at the product recall, how the implementation process, when you implement, what are the steps to be taken. So here, the manufacturer had said, you get reimbursement of the surgery as long as the revision surgeries take place within 10 years of the initial surgery. So revision surgery was done. He was reimbursed right up till 2017. Some 5 years after the last revision surgery, this patient goes and commences proceedings against the doctor in the private hospital where he had gone and said, I want my left hip done and I know which implant I want, and against that hospital and against the manufacturer. So he does that in 2022, in April of 2022. So this was the timeline of the events. Oh, it's very important to analyze this because it became very complicated. But when you look at it, it becomes very clear that he had his first left total hip replacement done in 2007, in August 2007 of the left hip, the right one in 2008 in April, and then he comes back in 2016. But the period for which of the recall and the surgery after which he brought the suit was 13 years and 11 months. Then from the recall, it was 11 years and 8 months. And again, it was very, very long. Why we went into these timelines was because clearly this patient was eligible to any reimbursement within the period of 10 years from the initial surgery. So that is from 2008, and that would be in 2018. He wants to come and claim right after that, and this is in 2022. And strangely, he claimed this from the doctor. He claimed the doctor failed to keep a record of the patients who used that implant, failed to monitor and check and organize the records of who used that depot implant, and failed to inform him of the recall of the defective implant that was removed. So this was very puzzling because the duty to keep records was that of the establishment, the manufacturer, also of the healthcare facility, but the doctor would have recorded and he moved hospitals. So he was not on a continuing duty to follow up on this patient because this patient was also discharged to another center and didn't come back. The manufacturer said he was informed of the recall. So this became a big issue that in 2010 he was actually informed of the recall. But this suit was brought. But what the court decided after arguments was this was barred by limitation. He brought it way too late. He could not have brought it all these years later, especially from 2010 to 2022. There was more than an 11-year period, and the court held that limitation ran from the date the cause of action accrued. That means the date of the recall, regardless of whether the plaintiff had discovered the damage or not. That's the law. So 6 years from the date he discovered it, he should have brought any action. This was way too long a time. The period of limitation under Section 6 of the Limitation Act must be strictly observed by the court despite the harshness, and the period is that of 6 years. And in Malaysia, a limitation period may only be postponed until discovery if the cause of action is based on fraud or mistake or concealed by fraud as provided in Section 29 of the Act. So in this case, there was no fraud pleaded. He knew about it. He had even gone through revision surgery at the expense of the manufacturer by a different orthopedic surgeon, and yet he comes back to sue the first orthopedic surgeon. So the court said this was a fit and proper case to strike out. That means they throw it out without it going to trial because it had come in way too late. So these are the issues that can arise, that will arise. So when there is a complication from the revision surgery, there would be a new time limit. But from the initial implant, which is what we're talking about today, the medical devices, it was the period prescribed. So what we are trying to establish is when you use medical devices, record keeping is very important. If you can show that it was all done within the time, records were kept. When the recall happened, the patient was informed, all those records, the courts will then weigh the documentary evidence. So like any other procedure, even when it comes to use of medical devices, record keeping is extremely, extremely important. So this was a good end to this case, and a lot of it was because of good record keeping, good recall. In the first case study, you found that because of the lack of calibration, there was going to be some liability. So these are all precautions that have to be taken. But when you use medical devices, always go back to the manufacturer to do what needs to be done, to get any updates, and to keep good records all the time. Thank you so much for listening. That is the end of my presentation today.
So, okay, thank you very much for listening to Datin Anit's talk. She's here, and I'd like to bring her onto the stage. And so please welcome Datin Adit. Hi, Adit.
Hi, good evening.
Yeah, thanks for
Am
the
I
wonderful talk.
audible? Am I
Yes,
audible?
sound is good.
Okay,
Yeah,
great.
sound is good. It's very clear. Um, I we have about 15 minutes for Q&A. I'm just checking the Slido. I don't know why
There are about
people
9
sometimes
questions.
struggle.
I didn't expect so many.
Yeah, there's Dr. John Doe has a string of questions for you, but before
Yes.
we embark on these questions, maybe I'll ask a simple one.
Yes.
Um, are we liable? Are we contravening the Medical Devices Act if we use a medical device which is not registered under the FDA?
Technically, you
Maybe
are.
it's not technically,
Technically,
yes. I'm just
yes.
worried because sometimes we don't think about it. Okay, it's not something we're going to implant in the patient's body, but it's a simple thing, like maybe even a blood pressure set. Let's say if I order a fancy, supposed to be very high tech, wireless cuff BP set from an online site manufacturer overseas who has no local uh,
Presence.
service partner in the country. But nevertheless, the purchase is made and the company sends it to me and I use it. Okay, but it has no MDA certification. But I
Yes.
find, okay, I compare manually, it's quite accurate, it serves my purpose, but it's not MDA certified. So am I technically breaking the law?
I wouldn't say you're breaking the law. You're using a device that is good according to your standards, but I wouldn't
Yes.
use it in a hospital setting. So what you do at home and monitor at home is something quite different, Dr. Tay. But if you're using it as part of your medical practice, the advice would be to go strictly with compliance with the Medical Devices Act and what your hospital would approve um, with, with their regulatory and compliance.
Okay. So let's say even we buy one of those portable pulse oximeters from online, if it's not MDA approved, then we shouldn't be using it in hospital at all, but it's up to the
We
consumer.
Yeah, it's up to
Yeah.
the consumer. We haven't found any big data on pulse oximeters being recalled. In fact, there's even an emergency section in the Medical Devices Act that in the cases of emergency, like during the COVID, they were instruments and devices could be used on an emergency basis. So, there was that period during the COVID time where they could have relied on that. And if you had done it then, I don't think anybody would have held you liable. But in your everyday practice, it's good to be extra prudent and, and comply with the act.
Yeah. But we do find like devices which are generally not MDA approved, and if they're particularly cheap, they are usually not so reliable and less accurate. Okay,
Yeah.
but those are the simple non-implantable things, and what you covered is the more serious ones where actually they're implanted, or there may
Yes.
be impact on the patient's health much more. Let's go to the Q&A because Dr. John Doe has got a lot of questions. So number one, how do emerging technologies, e.g., for example, AI, Internet of Things, impact the development and safety of medical devices? Don't know
Okay.
whether we can wrap our heads around that. Okay.
I have to say, when I read that question, I said, "Oh my God, I don't know this," and I will be honest enough to say I think this is a question for manufacturers to deal with. They have a legal framework, and I don't know what the impact would be as long as they can provide what the Medical Device Authority, which is established under the Medical Device Act, under the Minister of Health, and they can satisfy them. I'm sure these are hurdles that they would have um, to go through themselves, but I really don't have the answer for this. I know a lot of things are improving. I believe robotic surgery is a big thing. These are emerging technologies. There's AI, um, and I really would not know what
Yeah,
the challenges they actually face on the ground.
there'll be challenges which I think can only be assessed by the medical device authorities based on
Yes.
what information the manufacturer provides. I think. But it's sort of connected with the second question, which which is regarding increasing reliance on interconnected medical devices. What are the key challenges in ensuring data security and
Privacy.
privacy?
Okay.
Yeah,
I
privacy. Yeah.
I would say that uh, to answer this question, we would need a lawyer that is very equipped in technology and multimedia law, because this is when it comes to the law and on data security and privacy. Technology lawyers and multimedia lawyers are the people to go to. As medical legal lawyers, we tend to not encroach into that area, and I will not want to answer something that's beyond my expertise.
Yeah. I think that those are issues to think about nowadays. Like example, recently at my hospital, they launched Senior Connect, where they're going to connect monitoring devices to elderly people, and I think that these issues about data security and privacy will crop up. I think that's sort of similar to question number three on the interoperability amongst different medical devices. Now, not quite the same.
I actually think that when it comes to interoperability, as long
Not
as
quite the
those
same.
devices do not contradict each other and work in tandem, and each of them have been approved, I don't think you should have a problem in terms of a medical legal problem. Because
Okay.
as long as it's an approved device, you have the safety record, you have the service record, and they work together, I don't think it should be all, it's not like Apple and you need to then have an Apple
Hmm.
Watch and an Apple phone as well as a Mac computer. I don't think it works that way. I think it, they can be a
Yeah.
combination of Android and Apple, or whatever
Hmm.
it is in the medical terms, which I'm really not aware of. Um, but it can happen. I don't think there is any restriction, and the Act does not have any restriction on anything
I, s-
interoperability.
I suppose the MDA is just on that particular device, but it doesn't cover the interaction between different devices. That's
No,
it.
it
Is that
doesn't.
no?
It doesn't.
Mm.
And in fact, any application that you put in is actually confidential. The Medical
Mm.
Device Authority uh, perceives all applications made by manufacturers as confidential,
Mm.
and they
Okay,
will
let's take a
only
question.
breach that confidentiality if it is in the interest of public safety. So that's also in the
Okay,
Act.
well, let's take a question from Slido. And is there a protocol for proper disposable of devices, for example, X-ray machines and laser machines?
Okay, that would come from the manufacturer. The Act itself does not say that. It is very much dependent on the manufacturer. So the role of the manufacturer in marketing the device, selling it to you, and the disposal would be the prerogative of the manufacturer, and you really need to check with them on it. And they would also tell you that if you exceed this many hours without servicing, there can be a risk of higher radiation. So that generally comes within the manual. So it's a document that the manufacturer should be providing.
Okay. One more question from Slido. What about dental devices manufactured by dental labs, for example, anti-snoring devices and bruxism night appliances? I just Google bruxism, it's teeth grinding.
These are all devices as long as they are approved by the Medical Device Act, and the Dental Council actually has got an entire um, regulation on it. So the dental practitioners will have access to that. It's on the site of the MDC and Malaysian Dental Council, and they would be able to access it to show what the framework is on medical devices within the dental industry.
Okay.
So generally,
Uh,
the same thing applies. There's not much difference, but it is there's a specific one for the dentist. I was very impressed with that.
okay. Back to John Doe. Can you discuss the potential ethical implications of implantable medical devices such as neurostimulators or pacemakers in terms of patient autonomy and privacy?
Okay, as long as you have consent of the patient, you are exercising patient autonomy. So if you implant a device without telling the patient, except if it is for therapeutic privilege, if you have to implant one to save the life and you don't have time to get consent, that is going to be allowed. no ethical implication is going to be there. But if you implant one without informing the patient, well, I can't think of anybody proceeding to do a pacemaker surgery or insert a neurostimulator without a proper written consent. Then I don't think that would be an ethical implication there. But if you do, if anyone does, there would be ethical, serious breach of professional misconduct, and MMC would come down quite hard, right?
What
Privacy,
happens yes. What happens at just a theoretical thing? Let's say an orthopedic surgeon wants to put in a prosthesis and we
yes.
advise this model, etc. But when he goes in, it doesn't fit. And then on the table, he has to make a decision to switch to another model, which there was no prior consent. Is it a problem?
If it does the job, I'm really not sure. If it is not consented to, I would rather reverse the patient, not do anything, bring him out of or him or her out of anesthesia, and then take a consent and say, we had planned to do this, but this did not work.
Okay.
I would rather the doctor, as a defense lawyer, I would rather the doctor not proceed with that surgery, and
I
because
don't know
before
whether
any damage,
I hope there's
can happen.
I hope there's some orthopedic surgeons listening, and maybe they can share their experience or question regarding this, because I think sometimes, let's say you put in some metal thing, it doesn't fit, then you got to put in something else, and then that may be an issue. Okay.
I just
How
wanted
do
to say
regulatory?
I just
Yes.
wanted to comment, Dr. Tay, on that question of privacy, ethical implications of privacy. Generally, once you have patient autonomy, the patient will, well, if you've got a pacemaker inserted, you generally carry a card, and you would need it because you go through a lot of metal detectors in the course of everyday life, including the airport. So, if the patient was given that card and that card was then showed to someone else, that is the patient deciding on who to show it to for their purpose. I don't think the doctors generally disclose to anybody without patient's consent that this has been implanted unless there is a request. But generally, doctors are asked to write a referral letter to say this patient has undergone this procedure, this is what has been inserted, and that is quite in order, because that is required. And then it's up to the patient on who to disclose it to.
Sure. Okay. Question number 5 from Dr. John Doe. It goes down to 12, so we better skip through very quickly.
Yes.
How do regulatory bodies ensure the safety and effectiveness of medical devices, especially in rapidly evolving fields like wearable technology and so on?
I think the important thing is to liaise with the manufacturer. Your relationship with the manufacturer is what's important. The regulatory bodies would go within the framework that is set out by the Medical Device Authority. And if it is in compliance, they would, and as long as there's no risk to patient safety, they would give it a shot. And if at any point any complaints come, they are the first to alert you and ask you to recall. So they do their job according to the regulations.
Yeah, it's tough job when it's very, very fast moving. Okay,
Absolutely.
let's give others a chance here. And this is an interesting question from YouTube regarding single-use devices. Is there any case where an issue where single-use devices are used repeatedly? Say they are recommended for one use, but okay, in the name of economics, sometimes we reuse things and keep on using it until it cannot be used.
I don't know whether anywhere, I don't know of any reported case on it. Okay, I have not come across one, but I don't know how we would prove that a single-use device has been used repeatedly unless the medical records show, and or the staff or somebody who says this was used repeatedly. Generally, I know with hospitals, whenever any instrument, anything is used, it's written down, and whether it's a syringe, it's opened, and it's labeled, and there's a record. So I personally haven't come across any case, but if there is, there would be serious ethical issues with regards to that, especially if they are being billed for a new device or a new device, and one is being recycled.
Yeah, I recall many decades ago when I was a young doctor in a government hospital. I mean, the budget was very, very limited. So certain things like pacing wires and catheters would be sterilized, ethylene oxide gassed, and then reused. And the always fear is, say, if they worn out and they break and then something happens, the thing gets left inside the patient, how liable would be, should we be? And if it's found out that, oh, this is a reused device.
Yes.
I think this issue is much less now. I mean, with the effort, worry about sterility, safety, with more infectious disease going on. So we don't do that these days. But everything was reused. I can tell you, lumbar puncture needles, they were not disposable. They were metal, reusable things. And I think those are the bad old days.
Yeah.
So I
Yes.
think nowadays, probably not so much.
And I
Mm,
think today,
okay.
if something like this happens, the manufacturer will conduct an investigation, because if you say
Mm,
it was a device failure, the
mm.
manufacturer would come in and investigate. They would want to see how the device failed. They want a photograph. They want to look at the condition of the device, and they would be able to tell, I think, from condition, if they had manufactured it, whether it was first time use or repeated use. I'm quite sure they are
Mm,
quite with it when it comes to that.
okay. Um, and some of this Dr. John Doe's questions are a bit similar, so we'll just skip them and I'll pick and choose a bit. What are the challenges do plaintiffs face when pursuing legal action against medical device manufacturers, and how are these challenges being addressed?
Well, it depends on a case by case basis. I gave you two examples, and it depends on if you have followed the manufacturer's protocols and their SOPs, and if you have serviced it on time. These are the challenges that they would usually come to, and they would want to know what is the ultimate outcome, uh, because if any legal action is pursued, it's in the event this device failure has caused an injury to the patient. The injury would be compensated the same way if the injury had been caused by negligence of a doctor. It would be that same thing, because the important thing to establish would be what caused the injury. Was it the device failure, or was it the doctor's negligence in implanting the device? So that's how liability would be established, and it's all a question of what the expert says.
You mentioned in the second case the plaintiff had a problem because of the time lapse.
Recall.
So it
Yes.
lapsed, yeah. And
But in that case,
there,
even if it was a time lapse, even if it hadn't been a time lapse, he had already been given a revision. The manufacturer had paid for that earlier metal on metal to be removed, and a new safe implant to be inserted. So he was given a revision surgery at no cost to him, including the follow-up.
yeah, but maybe it's not so fair for this time lapse. Say if a case is discovered like an implant causes cancer 20 years down the line or 15 years
Yes.
down the line, So is there
So
some
the time,
recourse?
so the time lapse was from the date of the recall. It's from the date you know that there's something wrong with what happened,
Right. Okay.
right? And
Not
this
from
was
the
the
date of implant.
not from the date of the implant.
Mm, okay. So that should clear things up as long as something was found to be wrong. Of course, if
Yes.
it was doubtful whether it's related or not, but there have been a lot of instances. I remember there was one, I think for gynecologists, there's some mesh device for urinary incontinence, which is created a lot of controversy. Um, and I think people can read up about it, and it's quite interesting. Yeah.
The
Um,
the good thing
with
about your profession is they update the journals quite quickly. And the minute something happens, there are some journal reviews, there are articles on what to do. And because a lot of times these manufacturers are global players, they're not just local players, so you will have international data.
Yeah. Okay, two more questions. I think we are already over short time. Question is, do I need to process of registering my iPhone as a medical device if I use it to capture pictures and videos of patients? Actually, I just want to say
No.
there are a lot of devices we use in hospital. Day to day, we don't even think of it as medical device. Simple one is my pen torch. I use it to diagnose because I use it to examine patient, but it's certainly not MDA approved. And I
Yes.
don't think MDA will bother approving a pen torch. But I
No,
mean,
no, no, they wouldn't.
even
They wouldn't. They would. But
so, I mean,
if you're just using it as a recording device of pictures and videos, so your iPhone doesn't. It's not a medical device because it isn't. If you look at the definition that we put up earlier, the definition of medical device, it was
it's
something to
very
do with.
broad. It's very
Yes,
broad.
it's
Even used
extremely
in
broad.
diagnosis is very broad. Yeah.
Yes,
Mm.
but iPhone would only be used to capture data. So your hospital system where you document is not a medical device. Similarly,
Okay.
therefore, your iPhone is not a medical device because it's only
So a
used to
computer where we type in our medical records is not a medical
not a
device.
medical
So we can't.
device.
Yeah. Yeah. Okay. Last question. Quick. We just run out of time. Are there any notable trends or shifts in the legal landscape regarding medical device litigations, such as changes in liability standards or the role of class action lawsuits?
They are class action lawsuits. In fact, I think some manufacturers have faced them. When there is long-term problems for something that has been implanted, and even if it's recalled and revised, and if there's long-term complications, there has been class action suits. We see them not as often in Malaysia, although they have happened in Malaysia. I cannot say there's a notable trends and shifts. It's just there as it comes. But I will say this, like with all medical legal cases, society is evolving into an educated society that's aware of their rights. So when society members are aware of their rights, they will seek redress if they have any claim against anyone, with not just against the medical device company, but even against the doctor or against anybody that they feel has caused them harm. So generally, there's always an upward trend that we see, but I cannot say there's a shift in the legal landscape. It's just that society has become more aware of
Okay.
the rights.
Right. Thank you. One last comment, and this one I can answer. I can
Okay,
answer.
yes,
The
great.
latest Apple Watch can detect atrial fibrillation oxygen saturation. Should the Apple Watch be registered as a medical device? Actually, as an Apple Watch user, we were waiting for the ECG monitoring to come in for years. We are very far behind. I think Apple is a registered medical device for atrial fibrillation. Actually, we got the approval from the authorities, then only released the ECG monitoring capabilities to Malaysian users of the Apple Watch. So yeah, I think we are using a medical MDA authorized smartwatch. Okay, I think we have to. I know there are maybe a lot of questions, but is there a way they can reach you, Anit, if they have
Uh,
some questions on MDA or
yeah, they could send it by email, and I will do my best to respond. Or if
yes,
Dr.
you
Tay, you
can
could
share your
compile it. Yeah, or if you could compile it as
yes.
well. Shall I
Okay. If they post in our forums, they can ask in our docs forums. You're a docs member, you can post in our Facebook forums or in our Telegram group, and I'll forward the questions to you. Okay,
Thank you.
Anit. I think that'll be better than showing your email publicly here. So, okay, let's move on to the last bit of our session, and I think just implore you all again, please subscribe to our DOPS YouTube channel if you haven't, because that's the only way we can keep you informed, and it will help notify you, okay, as a viewer. Now, Anit has asked me to share with you a upcoming Medicolegal Society of Malaysia event. And this is regional conference on the 18th to 19th September 2023. So, and the theme is Connecting the Dots, Healthcare, Humanity, and Law. And if you are interested, you can register. The registration deadline is 31st July 2023. There's a QR code there, and you can scan it to get to the site and registration. Anything else you want to add, Anit?
Thank you, Dr. Tay, for publicizing this. We are very excited. We're bringing this conference through the Medical Legal Society after 3 years, and we're going to have many interesting topics. The topics are already on the conference website as well. So please join us as we will have more in-depth discussions.
Okay. So the moment has come now for all of you waiting for the CPD point. So you can take your phone, your MDA registered iPhone, which I'm not sure whether it is, but you can.
Do I get CPD points?
Presenter gets 5 CPD points, but we have to only if you're MMC registered doctor.
Yeah.
I don't know whether lawyers get points. We'll have to ask Dr. Shield so they can give you the point. But actually, for our webinars, the presenters actually get 5 points for presenting as a doctor. So it's not just 1 point for attending, 5 points as a presenter.
Brilliant.
But I'm going to just claim my 1 point. So you can take your phone, open the MMA app, and then scan with the QR code, right? And we at the MMA have made it very easy for you. And scanning is as easy as 1, 2, 3. Yes, I got the attendance marked successfully. So if you can't scan because you're watching with your mobile, what you can do is take a screenshot. Okay, I can't teach you how to take a screenshot with a mobile phone. On the Apple phone, it's pressing the side button and the power button. Sorry, not side button and the volume button at the same time. Then it will take a screenshot, save it to your album, photo album or gallery. Then you open the MMA app, and when you scan, it will say also you can. When you tap the scan on the bottom right, it will allow you to scan from your photo album. So that's how you can take with your mobile phone without while watching, okay, the event. There was a quick comment. She missed. Fatin asked just a date for patient medical record for medical device. 5 years plus isn't warranty.
No,
that
that was patient medical record for medical devices. How long you have to keep the records? The limitation period was different. The limitation period was 6 years under the Limitation Act, but the date for patient medical records to be kept is from how long 5 years plus the 2 years after. Yeah, if it's a pacemaker, that's for 5 years, you have to keep the records for 5 plus 2.
The records are kept by the manufacturer and the hospital.
Yes, and the hospital.
Okay.
It's totally different from a warranty. Totally different from a warranty. The warranty is issued by a manufacturer, and it's up to the end consumer to keep and exercise the warranty.
Okay. And the onus of recall or the manufacturing defects is on the manufacturer.
Yes.
Not the hospital.
Not the hospital.
Okay.
Unless the hospital or the doctor reports something that is untoward that happens after using the device.
Okay. All right then. So thank you very much, Datin Anit, for the wonderful talk and the engaging Q&A. And we'll have to, I think, put an end to this session, though you can go on and on if there are more and more questions. So I'd like to thank you again, and we hope to see you again in future sessions. So wish you all the best, and wish everyone watching have a good rest of the week. Okay, good night, everybody. So the stream will remain on, so you can watch it. And I think the QR code will still be valid for another 15-20 minutes, so you can still claim it by scanning. But if you miss it, say you're only watching tomorrow, if you're a registered docs member, you can go to our forum and then answer the MCQs, which we'll put up a bit later on tonight. Okay, so I'm going to end the broadcast now. So thank you for joining us again. So watch out for our email blast. There'll be another medical legal seminar next week and also another SGMC grand rounds. Just a little hint, it's not cardiology. It'll be a hematology grand round next month. Okay, good night.